In this video, I'm going to discuss the committal process in Queensland Magistrates Court. In Queensland, the law says some offences must be dealt with by the District or Supreme Court. If you plead guilty or are found guilty of a charge in the District or Supreme Court, a judge will decide the penalty you receive. If you go to trial, a jury will hear your case and decide if you are guilty or not guilty. No matter what offence you are charged with, you will start in the Magistrates Court. If your charge must be finalised in the Magistrates Court or Supreme Court, your case will go through what is called the committal process. During the committal process, your case will be mentioned before a magistrate several times. What are mentions in the Magistrates Court? When you go to court, you will hear people referring to mentions. A mention of a case in court refers to when a magistrate reviews a case. At the mention, both the prosecutor and defence lawyer will appear in court. The prosecution and defence will tell the magistrate what is happening with the case. The main issue talked about is the disclosure of material by the prosecution or lack of it. Do you need to go to court and attend the mention of your case? The general rule is you must appear at the first mention of your case, even if you have a lawyer representing you. However, there are exceptions to this rule, which I will discuss. If you have a lawyer, after your first mention, your lawyer can generally ask the magistrate to excuse your appearance at subsequent mentions. This is subject to you maintaining regular contact with your lawyer. If you do not have a lawyer, you must go to each mention of your case, or the magistrate will issue a warrant for your arrest. I'll now discuss the first mention of your case in the Magistrates Court. Do you need to go to court? Whether or not you need to go to court for your first mention depends on a couple of things. 1. How you've been charged. For example, have you been charged by way of a notice to appear? Or did police arrest you and charge you at the watch house and give you bail? The second issue is, do you have a lawyer representing you? If you've been issued a notice to appear, you must go to court, even if you have a lawyer representing you. If you've been charged at the watch house and the police gave you bail, if you don't have a lawyer representing you, you must go to court. If you do have a lawyer representing you and appearing at court for you at that mention, your lawyer can ask for your appearance to be excused. But please, first discuss this with your lawyer so to avoid any issues. What are your options at the first mention of your case in the Magistrates Court? Before your first mention, I strongly recommend you get legal advice so you know all of your options. If your case is being heard in the Brisbane Magistrates Court, the first mention of your case will generally take place at the Roma Street Magistrates Court. This is commonly known as the arrest court. At the first mention, the magistrate will most likely adjourn your case to the committal call-over, which takes place at the Brisbane Magistrates Court located on George Street. And this will happen on another day. However, please note the issue of bail will be raised at the mention. You generally have 3 options at the mention. Option 1 is you plead guilty. This is very rare. This rarely happens. If you do, you can accept the facts and charges alleged against you in the QP9 court brief. You can then have your charge committed for sentence to the District or Supreme Court. Option 2 is you adjourn your case to another date so the prosecution can provide material to you. You or your lawyer may want the prosecution to give you some material before you decide what you want to do. Your case can be adjourned to another date to allow the prosecution time to give you the material you have asked them for. This material may include witness statements or exhibits like CCTV footage, your interview with police, or text messages, etc. This adjournment should be for 21 days, and this is in accordance with Magistrates Court Practice Direction 9 of 2010. Option 3 is you adjourn for a full brief of evidence, and in my experience, this is the most common option adopted by practitioners. You may want all of the evidence the police has against you before you decide what you want to do. Your case can be adjourned to another date to allow the prosecution to give you a copy of the full brief of evidence. How long does it take to get a full brief of evidence? Well, there's no hard and fast rule to this question. Magistrates should follow Practice Direction 10 of 2010 when making orders for briefs of evidence. This practice direction states the disclosure of the full brief of evidence to the defence is to occur within 5 weeks, and then there's meant to be a mention at the 7-week mark. So you basically get the brief and have 2 weeks before your next mention. Sometimes though, the prosecution will be late in giving you the brief. The reason being can be for various reasons. Police can have difficulty in getting a witness statement from a witness because they're on holidays or don't want to cooperate with police. There may be delays. The evidence may take longer than 7 weeks to get. For example, DNA evidence, drug analyst certificates, or technical evidence associated with child exploitation cases can take longer than 7 weeks. So you get the full brief of evidence, now what? Once the defence has the brief of evidence, they'll review it. As part of this process, the defence decides if witnesses should be cross-examined, or if they'll make a no-case submission. If defence wants to cross-examine witnesses or make a no-case submission, this happens at a hearing called a committal hearing. I'll now discuss committal hearings with you. What is a committal hearing? A committal hearing is a hearing in the Magistrates Court. One of the primary purposes of a committal hearing is to make sure an accused is not caught by surprise at trial in the District or Supreme Court. In some situations, a witness may not have given enough detail in their witness statement. The defence may want to know the answer to issues not mentioned in the witness's police statement before the case goes to trial. A committal hearing allows the defence to ask a witness questions under oath so they know what the witness will say if the case goes to trial. Another purpose of a committal hearing is for a magistrate to decide if there's sufficient evidence to put an accused on trial in the District or Supreme Court. Now, does everyone have a committal hearing? The short answer is no. Not everyone has a committal hearing. Well, if not everyone has a committal hearing, who does? Or who has one with cross-examination of witnesses? The defence do not have a general right to cross-examine witnesses at a committal hearing. There are only 2 ways witnesses will be required to attend court to be cross-examined. This is 1, if the prosecution agrees to the witness being required to attend court to be cross-examined, or 2, the court makes an order for the witness to attend court to be cross-examined. If defence wants to cross-examine a witness at a committal hearing, they must write to the prosecution. The defence must tell the prosecution the following things. 1, the name of the witness they want to cross-examine. 2, the general issues they want to cross-examine the witness about. 3, the reasons why they say the witness should be cross-examined on the issues they have identified. 4, a time for the prosecution to respond to their communication. If the prosecution doesn't agree to the cross-examination of witnesses, the defence can apply to the court to get an order allowing them to cross-examine witnesses. So what happens if the defence apply to the court for witnesses to be cross-examined? If the defence apply to the court to cross-examine witnesses, the application is heard at a hearing called a directions hearing. To be successful, the defence must be able to say why there are substantial reasons in the interest of justice for a witness to be cross-examined. At the hearing, a magistrate decides if they will allow the defence to cross-examine witnesses. They decide what topics or issues the defence can ask each witness about. So what are substantial reasons? There's no definition of what substantial reasons are. However, cases have identified and includes those where cross-examination would or may result in the discharge of the defendant or lead to a successful no-bill application, where it's likely to undermine substantially the credit of a significant witness, is necessary to avoid the defendant being taken by surprise at trial. So what happens at the end of a committal hearing? At the end of a committal hearing, a defendant can 1, enter a plea of guilty and be committed for sentence. 2, enter no plea and be committed for trial. 3, make a submission to the magistrate to say there is not enough evidence to put them on trial. This type of submission is known as a no-case submission. So what is a no case submission? If a no case submission is made, the magistrate must review the evidence and decide if there's sufficient evidence to put the accused on trial. There is a test, and the test for the magistrate is taking the Crown case, that is the prosecution's case, at its highest, so the strongest it is. Has a prima facie case been made out? The test of whether or not a prima facie case is made out has been considered in various cases, but there's one case often cited by magistrates, and this is called Doney and the Queen. It's a 1990 High Court decision. It's published in 171 Commonwealth Law Reports at page 207. But at pages 214, 215, the court said, it follows that if there is evidence, even if tenuous or inherently weak or vague, which can be taken into account by the jury in its deliberations, and that evidence is capable of supporting a verdict of guilty, the matter must be left to the jury for its decision. Or to put the matter in more usual terms, a verdict of not guilty may be directed only if there is a defect in the evidence such that, taken at its highest, it will not sustain a verdict of guilty. In my experience, magistrates will often find there's a prima facie case. If a magistrate is satisfied there is not sufficient evidence to place an accused on trial, they must discharge the accused. What if your lawyer decides a committal hearing with cross-examination is not needed? If there's not going to be a committal hearing, then your case needs to be transferred from the Magistrates Court to the District or Supreme Court. Which court your offence or offences are transferred to will depend on what they are. The main way criminal charges are transferred from the Magistrates Court to the District or Supreme Court is by way of a registered committal. This doesn't involve a court hearing. The defence and prosecution complete paperwork, which is filed in the court. The court then prepares a document called a transmission sheet, which transmits the charges. What happens after the charges are transferred or leave the Magistrates Court to this District and Supreme Court? Once your charges have been committed, that is left from the Magistrates Court to the District or Supreme Court, the Magistrates Court will send you or your lawyer a transmission sheet. The transmission sheet is a document detailing several things, including the following: what the matter is committed for, that is trial or sentence. If you made any statement to the court about the charge, for example, no thank you, Your Honour, or guilty, Your Honour. The offences committed, that is the offences transferred, and the court where the offences have been transferred to, that is District or Supreme, and what your bail situation is, if you've been granted bail or remanded in custody. The prosecution has 6 months from the date your charge left the Magistrates Court to present an indictment in the District or Supreme Court.